all the hundreds of billable hours and all the work that Shannon Wilson could have been doing. Well, wait a second. What about T. Matthew Phillips? I am not, as this court indicated, addicted to litigation. I hate doing this.
Every order since then is wrong as well, and everyone needs to reverse every single order that happened against you, because you're totally right and everyone's wrong. The reason that I'm sure on a certain level, I'm sure he loved his son and still loves his son, and his pain from not having this relationship is palatable and real. But just because someone, love is a strong emotion, but that doesn't mean it's always noble, rational, and focused, and in the best interest of the individual who you love. It's far more complex than that. Loving your son does not mean it was in his best interest to literally, and it's not too strong a word, I will say it. So if me saying it is a basis for you recusing the court, then have at it, torturing her. And if Ms. Wilson feels that your client being tortured is an exaggeration, she will. She's highly honorable. She will say, Judge, yes, it's caused her a lot of consternation, but torture is too strong a word. Trust me, she will tell me that, and I will apologize on the record. But for now, until she does inform me of that, I don't think that's an exaggeration. So on one level, you do love your son, but you have an emotional, behavioral blind spot into how the damage this is causing him. His mom, and which you don't seem to care about, so let's just focus on him. All you care about with her is, I don't care how she's suffering because she brought it on herself because she destroyed this relationship between me and my son. And at this point, it's impossible for me to get in a time machine and go back and indicate who was more culpable at what time and who should have done this or that. Maybe if I was the judge since the inception, I'd be more able to, but at this, what I do know, which is resoundingly clear, is that the supervised visitation was commenced in the interim of the case, like 6 years ago when he's 12. And I mentioned last time in detail, it would have been relatively simple to visit in a supervised fashion a few times. And then I dare say the lion's share of these cases, once we get a positive report that the visits are conducted appropriately, the supervision is lifted. The relationship then starts growing from there in terms of just not quality, but quantity as well, in terms the visitation gets extended. You could, for all I know, you could have done a great job in this relationship, and who knows, you could have wound up with joint physical custody, maybe primary physical custody. We don't know, and we never will know. Because you decided to go in a very self-serving, sanctimonious, myopic, damaging situation where all you could see is, these are my rights, I love my son, and she's the culprit, she's destroyed it, and we should just assume that she destroyed it based on certain anecdotal conclusions or facts that you're offering me as to something very complex and multi-layered that's been going on at least 6 years. You could have easily just swallowed your pride instead of this fixation on being right. And you're saying, I wasn't fixated on being right. Well, of course you were. Because if a little humility, if we could have avoided that degree of hubris and just a little humility, okay, I don't agree with it. We've all done so many things in life that we don't agree to because some bureaucracies or some administrations or other people, whatever, demand it. And unless it's something so onerous that it's really damaging or compromises principles in some humongous way, we go along with it. All you had to do was that. No one was saying conduct 4 years of supervised visits, maybe just 2 or 3 visits. And if it was that wrong-headed an order, then you should have challenged it at that time with a rehearing. I should not be on supervised visits, or a proper appeal at that time. But if you took those actions and they were unsuccessful, you always had the opportunity for supervised visits. And so now he's 18, and for the reasons mentioned and supplemented significantly, mentioned by the court last time, supplemented significantly by the statutory case authority framework offered by Ms. Wilson, he's clearly outside the jurisdiction of the court. And I don't doubt that after 6 years, of voluminous and suffocating proceedings and all these ancillary lawsuits, all of that, as opposed to spending a mere, not a small, but a minute fraction of that time and effort on actually working on the relationship, would have borne fruit. You would have made probably very significant progress. You might very well have a very satisfying father-son relationship at that time. So, but, and I think what you're missing is, even if at this point he's against you, and even if you were right that despite the judge's findings that she encouraged it, that she did, let's say she did take a negative view at this point and not doing what she's supposed to, it wouldn't be, even if the court could find that wouldn't be sufficient, because the court would have to say, look at the effect of these 6 years of nonstop litigation on her, and the effect on him, and this fixation with and I do think everything I've heard today, you do love your son on a certain level, but this is about being right, and this is about winning, and you're not going to stop till you get the order you want. And the question I'm wondering, which I'm not sure of, even if you got everything you wanted, I think there would be a hole in your life. You'd have your son, but you wouldn't have the backdrop of this of spending your life on these various lawsuits and litigation. At this point, though, he's outside the jurisdiction of the court, and there's no conceivable, that not only was all orders to show cause on contempt baseless for all of the necessary statutory and case law steps, that almost none of them were met, but it was impossible from a willfulness or intentional standpoint for the court to pursue this. The court possibly could have pursued contempt against her at some point. It would have been 6 years ago. If you were appearing for the supervised visits orders and she wasn't, and it persisted, that would have been something where realistically contempt should be. But there is no orders against her to enforce, because you don't have any existing orders over the last 6 years. The only order you have of arguable enforceability as to visitation was a 6-year-old supervised visitation order that you were not interested in. Since then, you've obtained no orders that, now he's 15, he was placed on supervised visit at 12, but now he's 15 and dad has the right to come pick him up, and mom's being obstructive and all this. You have no such orders. So there is no order for her to be in contempt of that I'm aware of, and this is a voluminous case. There's no order she could possibly be in contempt of. You're quoting law or case law and statutes that you feel support a parent's rights to their child, but that's against the backdrop of appropriate orders to protect their best interests. And again, the only order that put an obligation on her that arguably could have conceivably led to contempt is 6 years ago, if she had said to the court, I don't care if dad's showing up pound sand, I'm not going to produce my boy for those supervised visits. So, but at this point, there's nothing she can be, there's nothing she can be in contempt of. B, more importantly, the court's covered this extensively, it completely lacks any remaining jurisdiction. And at this point, and if Ms. Wilson's indicating we don't necessarily have to go beyond that, and those are the rulings. Number one, no jurisdiction, he's reached the age of 18, no jurisdiction on to enforce visitation. And number two, that the court will not entertain, will have the obligation for arrears, so you do have to be aware of that, although I suppose that would be a DA support issue. Number one, no jurisdiction, so number two, any further motions would presumably be vacated. The court would review them just on the off chance that maybe that it's something mom wants heard because she has a counter motion for arrears or something, but presumably this court, number one, cannot proceed for lack of jurisdiction since the boy's emancipated out, and number two, the court therefore presumably will vacate all future motions. And if I had some idea as to how to, because it's a very, very upsetting, draining, aggravating situation where a person's, we want pro person the same reasonable access to the court as those people who hire expensive attorneys. And we need to all be committed to that. And Ms. Wilson's probably more committed to that than just about anyone else with the number of hours that she's devoted over her career to representing people at no charge who can't afford it. She may be in the top 3 in that area, if not number 1. So she's even more committed to that concept even than the court or just about anyone else. But if that concept means that someone who's using the court to enforce rights that no longer exist or for matters that the court has no jurisdiction on, and it's creating this type of incredible financial burden, not just to the litigant, but again, the Legal Aid Society could be servicing dozens, scores of other people for this. This litigation against the law firm, that even if it's dismissed and they get an attorney fees judgment, we kind of know what the handwriting is on the wall with that. That you can have all these non-collectible judgments. And I think the only thing Mr. Phillips might learn from, and it's not going to probably come from the Legal Aid Center, but if people or agencies that he's suing do get enforceable judgments and are able to attach property or wages, that may be the only thing that stops us, because I can't have this level of victimization. And that being said, the main issue here is protection of the mother from all of this. So now, Ms. Wilson, if you want to weigh in on this, there's nothing this court can think of that's going to stop this, because I don't think he's going to stop, but I am going to make him a suggestion. Number one, if the court recuses, it's not going to stop anything. He already says he's going to keep appealing it. He wants everyone disqualified, but then if someone disqualifies before he gets a chance to request that again, then it's something he didn't request, so then it must be bad. It must be something that he needs to attack. I think that would just do me to repeated procedures and appeals. If I don't recuse but simply decline to entertain future motions because there's a lack of jurisdiction, could do that, could simply say the case is closed, and maybe it's one of those few, and when there's no further jurisdiction, sometimes, even though the normal course is to dismiss without prejudice, I guess we can dismiss a case with prejudice as to the aspects of it where there's no longer jurisdiction, i.e. the visitation, and she can pursue her support remedies before the DA. So again, number one, if the court recuses, it doesn't stop any of this. Number two, if the court doesn't recuse but declines to entertain future motions, and maybe including up to and including closing and dismissing the case, I don't think it's going to stop, because, again, under neither of those scenarios did he get his way. And three, keep on the case and actually entertain future motions that the court has no jurisdiction on, would be the most ludicrous.
Can I ask a question?
Would be the most ludicrous of all, but at least probably would slow down or prevent a lot of appellate remedies. So I'd be very open to what can stop this, because access to court for some has to be balanced against protecting people and agencies and attorneys who are constantly bombarded by invalid matters and can't recoup their costs. Now, that's the rulings on the legal aspects of the case. If by some miracle we could capture lightning in a bottle, which I'm not foolish enough to believe, as I only think Mr. Phillips would, I'm not even sure he'd walk away from this if he got his son. All the court can do is suggest. And if it's not going to do any good, if Mr. Phillips isn't going to be interested in it, then I'll hear from Ms. Wilson as to whether she has any input on that dilemma that's upsetting the court greatly. Because I understand, not nearly to the extent Ms. Wilson and her client do, but I understand the real life impact of a lot of this. And when legal aid gets married to a case like this, that take hours, so many hours that would have converted to hundreds of thousands of dollars and hundreds of hours, and how many needy people could have been serviced in that for those efforts and hours. It's just mind-boggling. It's very upsetting. Now, if Mr. Phillips says, oh, that's all wrong, he thinks I'm this litigious harasser and all this, and it's not the case. I'm not trying to hurt her. I just want a relationship with my son. Well, let's strip it away to its simplest form. If your motivations really are that noble, and they just seem, because of the volume and tenor of all this, totally different to the court, this is the opportunity to get the court focused on the truth if you feel that I'm missing the truth. I can't order anything at this point. If you're interested, and if based on this you would suggest slowing things down, stopping all this at least for an indefinite period of time, I can suggest to them. They may say, no, it's counterproductive because it keeps this matter alive and it causes additional stress for mom and the boy. But maybe it causes, one shot at this causes a lot less than if we don't go this route and we have to continue with all of this. If they can produce for interview with a therapist, pose the question at this point without getting into the history, would you like to commence a relationship with your dad on any level, even though no one's going to be able to force it? With that information, even if the court can't enforce that, Dad, if you had that information and whatever it is he says, well, if this whole case goes away and me and Mom don't have to deal with all this, maybe I could start talking to Dad a little in a few months. I can't tell you when I'd start visiting, but it's up to me. I'm a young adult now. Would you be interested in that kind of input? Before I suggest to Mom that she even consider something like this, I don't even think she should consider it. I think Ms. Wilson probably thinks she shouldn't mess with it at all. But let's assume that it's viable for her to consider it if it's going to put a stop to everything. But let's say he did get interviews. Let's say you're not hearing what you want to hear. No, I'm not going to start just going over and visiting Dad right away. But let's say he says something to the effect, if all of this ends and he stops pushing all this, because don't believe it, even regardless how much Mom has or hasn't shared with him over the years, it's impossible that after all these years and the volume of all this, that he wouldn't be keenly aware. And it doesn't mean the other parent is alienating. This is a very complex, voluminous situation. If you got a response like that from an interview where he says, I may be open to something in the future, where it looked like maybe the ice was thawing a little bit if Dad backs off and all this, would that make any difference? And then I'm going to ask Ms. Wilson.
The question to me, Your Honor?
Yes, please.
Well, one thing I'm kind of curious. I want to ask Your Honor. You said several times you mentioned recusal.
At this point, I've made a voluminous record. If there's a lot of things in there that are wrong and offensive, they're part of the record. I'm unable to walk back from them, and you have them there in the record for your benefit. I'm not going to elongate this any further. I stand by what I said. Whether or not I can phrase things a little more circumspect, I'll agree with that. But at this point, would you be interested in anything like that? Do you want to answer that, or do you want to turn it around and say, well, I'm really concerned
would, Your Honor.
You said this or that?
If you let me talk, yes, I would be interested in that, although I would add one caveat. I don't think that putting a therapist is going to help. Just have him contact me.
It doesn't have to be a therapist.
Just if he could just call me. Let me say this, okay?
When I say interviewed by an outside individual, presumably a professional, could even be at no cost our mediation firm here. Of course, I'm not going to talk. That's the whole point. You can't. I've already established I don't have the ability to order him to call you, A, B, nor do I know that's in his best interest at this point. Would you be interested if they agree not to make, they can't make it a court order because there's no jurisdiction, and it wouldn't be enforceable against them if they decline and don't proceed with it, but if it's something she's willing to discuss with her client, I'm not going to ask her, if she's willing to discuss that, if you're pretending to misunderstand what this is about. Are you interested, let's say I had a specialist from the mediation.
Yes, Your Honor. Yes.
Okay. And if he indicated that he's maybe open in the future or whatever the case, are you willing to accept that? Or are you going to just proceed with all those?
If I can speak to him, I mean, it depends. Last time they tried to offer...
You don't understand. I didn't say that. I don't have the jurisdiction to say you can speak. I don't even have the jurisdiction to order this. I could suggest, if it's something the parties are interested in that might have some sort of effect on controlling this madness, if it does, or slowing it down, that you would have the benefit of an interview where where are we going philosophically?
If I can
If he said he might be interested in the future, versus there's too much harm, I can't see my dad at this point, would you be willing to accept what he tells the specialist?
If I have actual evidence that he says it and it's not hearsay statements, then yes.
It's going to be in the report. Would that be something you're interested in?
Well, yes.
Yes, but if I get my way on all these other things and you force him to see me and all, no, just if he's interviewed and he indicates either an interest at this time to some extent, or he indicates it's going to have to wait, but I'm open, would that information cause you to back off, respect him for a while, and respect what he's saying? Because he didn't cause.
Yes, I've said a dozen times. Yes.
You two and your conflict caused it. Probably more one side than the other, obviously. But you two and your conflict caused this. Not he didn't cause it. So would you respect it?
Said yes several times.
Okay. Would you respect it regardless of what he said?
Well, again, I would like to actually know that he said it, but yes.
We're not doing a negotiation where you get to add caveats and qualifiers on this. I'm struggling, and maybe these are bad suggestions I'm coming up. I'm trying to come up with something, and it's probably not a good idea, but anything. But if they agreed, it's not an enforceable, it's not an order, I don't have jurisdiction anymore, but if they agreed in spirit, okay, bring them to the mediation department. We don't even need return court dates. Dad, the interview will be sent to Dad. And that doesn't mean you say, well, I'll see what the content is before I agree not to proceed with all this other stuff, or I'm going to object that the report's here.
No, I'm not saying that. I'm not saying that.
Would you respect what's in that report regardless of what he said?
Yes.
Okay. No qualifiers, right? Okay. Okay, now, Ms.
No
Wilson,
qualifier.
Thank you. Ms. Wilson, first question has to do with when I was struggling with 3 possible closure rulings for this case, and whether any of them do any darn good at controlling this runaway train. And that would be my first question, whether you have anything, and I'm sure you do, because constructive on that would be really helpful. And number 2, you heard this about a suggested interview, and whether that's something, it wouldn't be an enforceable order, wouldn't be an order at all, whether that's something you want to discuss with your client later, or whether you categorically think it's a non-starter. So let's start with number 1, the 3 options about if I recuse, or what if I don't recuse, or what if I keep on the case and actually entertain, well, I can't keep on the case and entertain motions, there's no jurisdiction on it. I can keep on the case technically, but recuse and dismiss it, remain on the case, but dismiss it for lack of jurisdiction. Does any of that make any difference how it's classified, or none, or what are your thoughts on all that?
So the recusal question is the easiest one. I don't think there is any basis for your recusal. Okay. The second question, do you dismiss the case now? I think let me say a couple of things to ensure that I understand what it is that you're saying. In the ordinary course of a divorce and custody proceeding, the case is closed after a decree is entered. It may subsequently be reopened during the minority of the child in order to address post-divorce child custody issues, as has happened here. But once the child has turned 18 and the court lacks jurisdiction to make any custody or visitation orders, then again, normally we would just close it. We don't say that that case is dismissed with prejudice. So if what you're suggesting is a stronger mechanism to signify that this matter is closed, well then, I suppose it's one idea. It's not one that I've ever thought about whether the court has the power to do that.
I don't know.
Conceptually speaking, you know, as with this very motion that Mr. Phillips brought, I think that we should be very clear that if it did not have the jurisdictional defect, that the orders do not require to do anything, well then the court would have had jurisdiction to enforce those prior orders, right, and grant whatever relief the court may have had jurisdiction to grant. And so that would be, my concern would be analogous to that, which is if the court were to now attempt to dismiss a case with prejudice, if there really was anything that could be brought, then that dismissal with prejudice could be set aside.
Yeah,
So I think that
the court did attempt to make clear that, number one, the jurisdictional defects preclude the court from proceeding, plus number two, even if there were jurisdiction, there's no enforceable orders against her for contempt or enforcement purposes otherwise. So I guess maybe I got into the weeds too much. Maybe I needed to paint with broader strokes. Is there anything that is there anything this court can do that might have a stronger effect on slowing this down, reducing it all, not just here, but across, well, I guess as other courts, agencies, separate lawsuits, I guess the answer is no. But is there anything the court rationally, legally, procedurally can do?
So I think that what the court can do is that the court can enter an order in light of there being no further jurisdiction because the divorce is concluded, because the child has turned 18. This court no longer has jurisdiction over those matters, and in the court's current order, it might then say that if any subsequent order were filed in this case, that it would be reviewed by the court, and would have no obligation to respond to that motion until the court ordered her opposition or response to whatever the filing may be. That would be one suggestion I would have.
Okay. And
With respect to...
We'll order that, just to make clear, the court will order that. Number one, which...
Okay, thank you, Your Honor, I appreciate that.
Number one, the court has no jurisdiction over any financial issues relative to the divorce that's long ago concluded, nor any jurisdiction over custodial support matters as the boy turned 18 in November. Number two, if there's any subsequent motions, they'll be reviewed by the court and presumably be vacated because on account the court lacks jurisdiction. It's hard to imagine any issue could be identified that the court would have jurisdiction on. But with that being said, the court will review those motions and continue to vacate them without the necessity of an opposition if it remains centered on this issue that the court has no jurisdiction over. No jurisdiction over visitation, and certainly no jurisdiction over any remaining divorce property or / financial issues, which has not really been brought up. So those will be the rulings, and you can place those in the orders. Now, on that other matter, it doesn't sound like my dialogue with him was at all productive, so you only need to respond to that if you want.
I do want to just go back to one point. I think it was just you just misspoke quickly. You used the word custody support.
No, custody.
There is an ongoing R case.
It was custody / visitation.
Yeah.
Number one,
Okay.
no jurisdiction over any divorce matters, no jurisdiction over any custody / visitation matters as the boy turns 18. A2, if any subsequent motions, they'll be reviewed by the court, and if their motions continuing to be based on the enforcement of visits and contempt, which the court has no jurisdiction over, they will be vacated. And I guess we'll make it four items actually. Number one, court has no jurisdiction. The divorce is concluded, the child is 18, so there's no jurisdiction over custody / visitation concerns. Number two, in addition to number one, no jurisdiction, no enforceable orders against the plaintiff exist, and the last enforceable order was a 6-year-old supervised visitation order, which it appears she was willing to comply with, but dad didn't appear for the visitations. 3, if there's any subsequent motions, they'll be reviewed by the court, and if they remain on matters that the court has no jurisdiction over, such as visitation, they'll be vacated. 4, however, plaintiff is not precluded from filing support and arrears motions either before this court or before the DA family support. And if that's the case, maybe you don't want this matter technically closed, I don't know. Ms. Wilson?
Well, there is an R case that is open.
Right.
So I don't think that that the orders you're suggesting to make today affect that in any way. I would like to make one point about the vexatious litigant designation, Your Honor. I brought that request twice, several years ago, in the form of a counter motion to an opposition. And it was ignored in one instance, and in the other instance it was in conjunction with one of the motions that Mr. Phillips had brought to disqualify Judge Ochoa. That was heard by the prior Chief Judge Bell, and she stated in her order that denied the motion for Judge Ochoa's disqualification that whether or not Mr. Phillips was a vexatious litigant was something that would have more appropriately been decided by Judge Ochoa. Thereafter, Mr. Phillips filed a series of successive motions to deem Judge Ochoa vexatious, to deem Judge Ochoa, to have Judge Ochoa disqualified, such that there was never another opportunity for me to bring back that motion to deem Mr. Phillips vexatious. In other words, there was never a point when I had a sitting judge that I could bring that before. And then after Judge Weiss went against Judge Bell's prior 7 or 8 rulings, then we had a series of judges who either recused themselves or who Mr. Phillips sought to disqualify. And so again, I had no judge in front of which I could bring that motion. And then once we did have a judge before whom I could bring that motion, we were distracted by many other things, and then Judge Parlati actually invited that motion. And then, of course, Mr. Phillips got her recusal too, and she voluntarily qualified herself. And so now here we are today, and that is my long-winded way of saying I'm not so sure that deeming Mr. Phillips vexatious would not actually work to stop him. Mr. Phillips, as he always points out to us, has been licensed to practice law in California for more than 30 years.
I've talked to Ms. Wilson. Obviously, yes, vexatious litigant status can be very challenging, particularly on review. I find that in the absence of it, the other standard can work just as well. The court has to meet a lot fewer procedural legal steps for a heightened scrutiny standard where it does have the ability. In fact, under the local rules, technically, any motion conceivably could be handled without a hearing or without an opposition. But under the heightened scrutiny standard, maybe we can get to the same place as a practical matter. Do you believe we can, or maybe both standards can be applied? I don't know.
So here's what I would say. You have pointed out that myself and my firm have spent inordinate time and resources on this one case that could have been devoted to many, many other cases. And so I don't actually want to spend any more time or resources to write that motion or have yet another hearing. Right. And so I will be satisfied with the orders that Your Honor just articulated to close this case. And with Mr. Phillips understanding that if we see any more motions, then we will not hesitate to bring the motion to deem him vexatious. And I think he has now heard from Judge Perlotti and from you that those motions are going to be granted.
Okay. Now,
and then we would subsequently use them in any other proceedings. I am not aware at this moment in time that there are any other open proceedings in any other courts against Ms. Phillips, legal aid, any other judicial officers, myself or my firm. So I don't think, unless I am just unaware of something that's out there, I don't think anything else is pending. And I am hopeful that the things that Mr. Phillips has heard will stop.
Maybe the situation's no longer nearly as bad as I believed it was upon review as far as all these collateral things. A lot of them are internal disqualifications, as you know, lawsuits against judges, all that. But now, so you're indicating that you'd be satisfied with a heightened scrutiny standard and the matter can be closed, but without prejudice as to child support issues which the court still retains jurisdiction over.
Correct.
Okay, now I have another question for you, because maybe I don't understand. I was struggling to understand Judge Weiss's order, because you can't disqualify a judge by artificially creating a subsequent conflict against them, like by suing them. And the most common attempts were made years ago. This was put to rest in criminal cases decades ago. You don't cuss out a judge or say vile things against the victim in front of the jury or judge in order to pollute the record against yourself so you can trigger a mistrial assignment of a new judge, inordinate delays. And that's been extended over to civil cases with the point you can't artificially create a conflict. Now, I understand Judge Weiss was focusing on probably the objective individual standard. Would they think if a judge is being sued by a party, isn't it difficult to accept that the judge would by necessity be totally objective and fair? But with that challenge being understood, have there been changes in this area that I'm hitherto unaware of? Because I don't think the conflict has to be based on the judge's actual conduct that may be questionable, or if not questionable, how it might appear. But a person can't create that with their own artificially created conflict of, well, I couldn't get rid of him or her that way, so now I'm going to sue him, and the chief judge will then probably grant the recusal. So was there some rationale to that opinion that I'm missing? Do you have the same concerns, or do you think it's proper to disqualify a judge if someone takes actions against them like that after because they don't like an order?
Judge, I think that your understanding of this case law is largely correct. There is one narrow case in which, and it's a federal court case, I don't recall it off the top of my head, in which a litigation can be commenced by a litigant against a judicial officer that may, in fact, give rise to the kind of disqualification that we saw. However, I do not believe that Judge Weiss really adequately set forth his findings to support the order that he made, in no small part because literally nothing had changed before Judge Bell had denied a motion literally 30 days before Mr. Phillips brought the new motion, and Judge Weiss's order. So we asked for reconsideration or clarification on that, which we did not get, and there was simply no reason or opportunity for us to bring a writ petition on it. So we didn't. Okay. We also felt like Judge Ochoa had probably served this case long enough, and he deserved a break.
Sure. And I wish that was that.
Honor, let me
so, Ms. Wilson, is it tilting at windmills for the court to even think it might be worthwhile to pose to your client? In fact, after he put all those qualifiers in place, I don't even think it's fair to ask you to speak to her about that. I think it would be a fool's errand almost. Even though at the end he said, yes, no qualifiers, I would live by whatever that interview report says. But I don't think it's rational for the court to accept that representation at this point. But that said, do you have any commentary on that, or is that not necessary to comment on?
That to me, Your Honor?
Well, first, Ms. Wilson, it's something that can just be a suggestion she can consider to her client if we don't hear back.
No, I appreciate that you understand that this is a very difficult situation in which to put either me or my client.
Sure.
And so I don't want to answer the question.
Fair enough.
What I will say is this, which is what my client has texted to me, because unfortunately we couldn't be in the same location, and that is that does now and always has had the ability and option to contact his dad anytime he chooses, and including now.
Okay.
That's the only comment that we have.
Thank you very much. Before I ask Mr. Phillips if he needs closing remarks, I will accept additional remarks for the record, but the rulings have been issued. Number one, there's no jurisdiction, the divorce itself, and any issues attached to the divorce. There's no longer anything enforceable as to the divorce. More to the point, this dispute revolves around enforcing child visitation. Child is 18, the court lacks jurisdiction. Number two, there's no existing orders that the court can enforce against mom, either by contempt and or enforcement proceedings. Number three, any subsequent motions will be reviewed by a heightened scrutiny and will be vacated from calendar if they address the visitation issue, which the court has no jurisdiction to entertain. Four, however, child support arrears motion and enforcement motions can be entertained by this court or the DA Family Support Court, and the case can be reopened for that purpose. But with those rulings in place, number five is that the case is closed, dismissed without prejudice, and can be revived by a valid motion. And the court's already defined what a valid motion is. Anything having to do with the visitation is no longer valid. It's beyond the jurisdiction of the court. But child support enforcement, which I haven't heard that she is any looming intent to pursue, but the court would have jurisdiction over that, and the case could be reopened for that purpose. With that being said, Ms. Wilson, is that all sufficient for preparation of the order, or is there anything else you want to mention before I turn to Mr. Phillips?
So I think
there's some items he wants to add.
that is all sufficient. I would just put a slightly finer point on the order to include language that if a motion is filed, then Ms. Phillips is excused from, and I don't have the relevant site here right now, but the PDCR section that says an opposition is due within
Yes,
14.
if,
I would just put that fine point on there.
Number 3, if any subsequent motions are reviewed from the court
Yeah.
and vacated, which would of course include motions on the controlling central issue here, which child visitation, which the court lacks jurisdiction on, it would be vacated by a minute order, which would of course indicate that that she need not respond. And it is acceptable and is not considered ex parte communication, but is a procedural communication that Ms. Wilson would be entitled to contact the court, and in an abundance of caution, CC Mr. Phillips and make sure they have your email indicating to the court a motion's been filed, because sometimes, candidly, we don't know what's on the horizon days or weeks from now, because we're kind of consumed with reviewing the week ahead. So we may not know if someone files a motion where it's to be heard in 7 or 8 weeks, and yet they have to get a response in within a couple of weeks. So Ms. Wilson can contact the JA, or better yet, the judicial law clerk, and they'll bring it to my attention, and a minute order, not may, but would occur, that indicates the matter's vacated and no opposition need be prepared, and Ms. Wilson can include that in the section that any subsequent motions on visitation would be vacated as the court lacks jurisdiction. Very good. Mr. Phillips, those are the rulings. If you have matters you wish to state for the record, that's fine at this point.
Yes, I do. And I would ask that Your Honor allow me to speak, uninterrupted here, because there's several things I'd like to say. I just wanted to point out that when I made the offer that there would be no more litigation if I could only see my son, they've made no response to that. All they would have to do is one single phone call from my son, and it would alleviate all this. But clearly, they don't want to do the phone call. That's alarming. They'd rather have me try to keep spinning my wheels. I find that very disconcerting. Another thing I'm kind of upset about is Your Honor is presuming that Donna's House would give me a favorable report. Well, Donna's House is in business to make money from litigants. In my experience is that they don't give people favorable reports. They string them on so they can earn money. On to the next point. I find it disconcerting, all this Judge Weiss issued an order disqualifying Ochoa, and it's raised judicata. I don't think it's appropriate to try to second guess it. I am aware that a litigant cannot artificially create a conflict. I think that's the words Your Honor used. That's very true, but I didn't artificially create a conflict. I sued Ochoa for non-judicial acts that occurred outside the bench in February of 2020, and I didn't seek to disqualify him for many months later because I wasn't aware of the doctrine that says if you're adversarial with a judge, that's a basis for disqualification. So it wasn't like I said, hey, let me sue the judge, then the next day try to disqualify him. That was never, the lawsuit was bona fide. The federal judge indicated that my issue with Ochoa was an issue of first impression. So it wasn't like I was just reaching at straws for any reason to sue him. Another thing I wanted to make is I've heard Your Honor say, and I just am so disappointed by this, but Your Honor seems to disparage me for wanting to be right. And I just wish that the courts would be as right as I am. If we look at the case of Roe versus Roe, that is an appellate decision from July 27th of 2022. I remember it like it was yesterday. Some woman only had 6 hours of visitation, and the appellate court, Justice Gibbons, said violated 14th Amendment right because she had no parenting time. Well, for goodness sake, I have less parenting time than the mom in Roe. The point is, I am right. There's no basis to declare me vexatious. It's just that the courts have not been following legal precedent, and it's enormously frustrating. On to the next issue. I've heard Your Honor say that she's has been devastated and punished, and all the hundreds of billable hours and all the work that Shannon Wilson could have been doing. Well, wait a second. What about T. Matthew Phillips? I have a career. I could have been making plenty of money and paying child support if I didn't have to bring these lawsuits. But I put my son first, and it's just shocking to me that the court is not considering how much time I've had to waste. I am not, as this court indicated, addicted to litigation. I hate doing this, but frankly, I don't know what else to do. I made an offer that I would suspend all litigation if only I could talk to my son. No response from Shannon Wilson. Whenever Shannon Wilson files a motion, there's never a meet and confer. They have no intention to try to take even one step back. They are the ones, I contend, who are litigious. They are the ones who are vexatious because they will never meet and confer on anything. And I believe Shannon Wilson is getting paid because, from what I've been able to learn, is absolutely unique. I've talked to hundreds of people in this town who have tried to apply for legal aid. And as far as I haven't found even one litigant, and yet keeps getting a litigant for 5 years, and in jurisdiction after jurisdiction. I believe that somebody has paid 501c3 corporation, known as Nevada Legal Aid, to keep me busy. That's the only thing that really makes sense here, because I have no interest in pursuing this, and they tell me, Wilson indicates that they have no interest, but yet it goes on, and they will do nothing to take a step back. All they would have to do is get the minor child to make a phone call, and that's never happened in the 6 years. That's just amazing that that's gone on like this. The other thing I want to say here is, Your Honor has wondered about what motions I may be making or not making. There are a couple motions that I intend to make. I wish to disclose those to the court right now. I want to vacate Ochoa's order of December 19th because case law in Nevada is clear and unambiguous. Once a judge has been disqualified, not a self-recusal, but once they've been forcibly disqualified, then their rulings are a nullity, meaning null and void. Now, I've brought this motion to vacate the order on several times, but it keeps getting, taken off calendar. So heads up to the court and opposing counsel to the extent it's relevant. I intend to make a motion to vacate Ochoa's order of December 19th, because in the words of Jerry Weiss, both Ochoa and I were adversarial at the time. There was an adversarial posture. The second motion I want to make is to modify child support. They imputed child support based on $60,000 a year. My tax returns over the past couple of years shows I've not made close to that, because I've been busy spinning my wheels in family court. So I do want to make a motion to modify the amount of child support I have to pay. And there are two additional motions I want to make. With respect to Regina McConnell and Parladay, I made motions, I filed affidavits against both of them to recuse. As Your Honor presumably knows, when a person like myself, a litigant, files to disqualify a judge, the judge shall take no further action. That is black and white from Nevada revised statutes. There is essentially what I would call an automatic stay on judges entering. However, both Parladay and McConnell issued orders saying that I was lying and I'm all sorts of things, factual findings that they made after I filed my affidavit to disqualify. Now, if McConnell or Parladay wished to challenge my affidavit, they could have filed competing affidavits, but they filed orders recusing themselves. And generally speaking, an order of self-recusal is a one-liner. You know, in order to avoid the appearance of impropriety, I hereby step down. McConnell and Parladay didn't do that. They made findings of fact, and so I intend to file motions under Rule 60 to vacate those motions, those orders from McConnell and Parladay. Now, Shannon Wilson can stipulate to the vacation of those orders right now. I suppose the court could do it too, but I just want to give the heads up. These are not vexatious. These are not intended to devastate or terrorize. I'm trying to recall the adjectives Your Honor used. I'm not trying to torture her or harm the opponent in any way. I simply want to vacate the December 19th, 2020 order because Ochoa was legitimately disqualified in a well-thought-out decision by Jerry Weiss. And number two, I want to modify child support because there's a significant change in circumstances, i.e. my income. And last, I wish to vacate the orders from McConnell and Parladay where they're making factual findings, which goes in direct contravention of, I want to say, NRS 1.235, which says after the affidavit is filed, a judge shall take no further action. And I'm just assuming that McConnell and Parladay, being relatively new judges, were just unfamiliar with that. But that's the future litigation I plan for this court, and if it's possible to stipulate to resolving any of these issues at this time, in the interest of being eminently reasonable, like I always am, then maybe we can resolve it.
To do that, I will make a couple, hopefully quick remarks on that. If a judge's disqualification is sought, it means they take no substantive action on the case, but it doesn't mean they're limited to just one sentence. I have no prejudice, there's no basis for removal. They can and correct the record. If someone was saying at a certain hearing, the judge made these rulings or made these comments, and if that's false or it's quoted out of context or distorted, the court has the right to comment on that. I don't know if that applies here or not. The more interesting
it doesn't.
Okay. They do have that ability, and they usually do offer more detail than just I'm prejudiced or I'm not prejudiced. They usually will explain, hey, the litigant said this or that. Let me tell you what the record speaks to. They do have the ability to say that, and if they didn't, Bill would have pointed that out. But moving on to the issue of no further action can be taken, it's sort of that's true, but here's how it would work. Like, if you were to, let's say, file to disqualify this court, which I think there was, I could be wrong, I think there was already at least one attempt on that, I could be mistaken. But the, take no
Not
action,
on your honor, no.
Okay, fine, very good. Take no action means that any motions would be held in abeyance. That's true, that any motions would be held in abeyance, they'd be continued out. The court wouldn't even dismiss them or resolve them for lack of jurisdiction. But if the disqualification fails, then the removal of those matters from calendar based on lack of jurisdiction would occur at that time. I still think that the commentary about the profound effect this had on, number one, Mom, 2, Legal Aid Center, 3, Ms. Wilson and her firm, if those statements are inaccurate or hyperbole, I think they're in an intimately better position than you or candidly myself.
But what about me?
I'm addressing that, to correct that. And you say, well, because when you're saying, but you're operating from a framework, if everyone had done what I demanded they do, which they needed to do under the law, I wouldn't have to gone through this and be devastated, like the court is saying they are. But here's the problem. You're aside from your irrelevant reference to Roe, which has no factual connection to this, here's the problem that you're missing. This problem is not caused by courts ignoring your rights because they didn't pound on her and force her to turn child over and hold her in contempt. This all started because you decided that you were not going to exercise the supervised visits. And yes, you could have avoided all this 6 years ago, because you and I have vastly different opinions. My experience with Donna's house, which I think is far more voluminous than yours, is quite different than yours. The majority of the time, if not the significant majority of the time, a report is generated that enables the court, which is the court's goal, to remove the supervision. So if you had just not dug your heels in on principle, well, your definition of principle is it's a principle stand if not everyone caves into my version that I'm right and everyone else is wrong. If you would just exercise a little humility, a little patience, just showing up for 2 or 3 visits, I happen to be confident that we may very well have received the report that we needed. That's what I meant about being addicted to the conflict and having to be quote unquote right. And even then, even when you missed that opportunity, for the last 6 years there was multiple opportunities to return to court and say, okay, let's restore that supervised visit, or let's get him interviewed by a specialist. But now, right when it's dumped into my lap months before he's 18 and now that he's beyond 18, those are the courts. I know it doesn't make any difference to you as to all that. And now, if as I said, if Mills, and the court, any motions to lower support would have to, even though the court has jurisdiction over that, those are generally vacated unless the court can make a finding that someone's been operating in good faith. You would have to establish by that motion, and I think it's best for the DA, or you may even be well served to wait to see if she's even seeking back support, rather than sticking your head in the lion's mouth and creating this big problem. But that all being said, that I don't think that's prudent for you, because they're not coming after you for that at this time. They kind of want to be left alone is what I'm hearing. But I suppose a motion like that could conceivably be entertained, but it would have to fully establish the trajectory of the reduction in income, that it's legitimate, that you pounded the pavement, you made all efforts to replace the reduced income or to obtain a new position, and that you've been in good faith paying as much as you can each month with a matrix of how much you paid each month. And I'm telling you in advance, the court is not going to accept anything, that it'll be vacated if it includes a nonsensical argument. I was so consumed with the litigation that this is one of the reasons why I was too stressed and busy to work and to maximize my income. That will be rejected because they had no choice but to defend at the cost of hundreds of hours and hundreds of thousands of dollars the agony you're putting them through. And yes, I stand by that word. Well, you get up in the soapbox and try and make yourself sound noble. Well, look at what I went through. But that's because you're looking through the prism that, oh, all of this was wrong, and that automatically from the beginning whatever judge was assigned should have pounded her, forced the boy to visit, and we wouldn't have had any problems. No orders in that instance were going to be made against her or compelling the visits, in your case or any case, until someone complies with supervised visitation. As soon as the judge orders that there's to be supervised visitation, unless you convince that judge or an appellate court to remove that and that was erroneous or wrong, no judge that I can see, unless it's determined that there was zero basis for that to begin with, which you would have had to establish that, no one says, okay, someone decided not to exercise supervised visits or give him 2 days a week for his child. That is where your whole, you'll never believe it, but that's where your whole problem stems from. You can rationalize it all you want. Oh, they're just in the business of making money. I'd still be on supervised visitation today's date. That's wrong.
But that's a question.
I'm just telling you, it would have been any time during the last 6 years. You'll spend the rest of your life convinced that everyone should have ignored that supervised visitation order, and just reversing
Can I
it
ask you a
at
question?
that time and giving you the order that you had unimpeded access to your son. But you didn't, A, you didn't comply with the supervised visitation order. B, you created then 6 years of non-contact with your son. C, this acrimonious, soul-draining litigation. And he's in the position he's in now where, as far as we can tell, he's not interested in visiting. If that's wrong and they want to consider the offer of an interview, which I can't compel them to because we no longer have jurisdiction, she will talk to her client about it. If they decide this could be some way to slow down or prevent or eliminate litigation, she'll discuss the ins and outs of all that with her client, and they'll let you know. And if that's, but you know,
Let me ask you a
that's the only way
question,
you're gonna
Your
get. If they decide to go that route, that's where you may get somewhere. But you're not gonna get anywhere saying, no, I'm right, everyone else is wrong, unless you issue these orders. Your whole presentation is based on, these are the orders that needed to be issued 6 years ago, not the orders which were issued. Every order since then is wrong as well, and everyone needs to reverse every single order that happened against you, because you're totally right and everyone's wrong. And you're never gonna see that. And you're obviously very intelligent. The fact you haven't figured out that banging your head against the wall for 6 years, ignore that man behind the curtain, ignore that, ignore that I never complied with the basic fundamental orders of visiting to supervise to assure the court there's no problem. Just let me keep pounding on everyone into oblivion, attacking 18 million judges, 20 million lawyers, just a gazillion motions. I'm right. That's all this amounts to. And
But Your Honor, please let me be heard.
I'm
Please let me
trying
be
to
heard.
I'm trying to get through to you. The fact you still want to be heard means I was foolish and I wasted my time to point these things out, which I pointed out 20
No, not at all. I have some information I wanted to give to the court. There are at least 13 Supreme Court decisions that are binding in all 50 states, which says that a person...
You haven't listened. There is no Supreme Court decision that forces the court to say a parent has automatic constitutional rights to unimpeded access to their child, even if a court saw fit to place them on supervision. There was no compliance with that supervision, and that order was never overturned. Whatever that judge's rationale for that supervision, that needed to be accomplished prior to that. So you keep quoting orders that stand for general constitutional concepts of a parent's right to the child, have nothing to do with the factual issues in your case. And in all of those cases, they are generated from fact patterns where people were wrong, where people fully complied with orders and were wrongfully deprived by the other side. You didn't comply with the most fundamental initial order, nor did you ever indicate a willingness to comply with anything again. I conveyed to them, and if you're interested, I don't think you are interested, even if should they not bother with this? I don't want to torment them and aggravate them with an additional project or suggestion, which Ms. Wilson said she's not going to react to it one way or the other. There's too much going on. She'll speak to her client about it later, see if it's feasible.
I don't think they ever will, because they keep winning. Because
Okay.
Let me ask you: Is Dawn's
if this is how you define winning, it's going to keep happening as long as you keep this approach. I'll if I need to entertain your reduction of support motion, happy to do it. I'm not going to I can't deal with this visitation anymore. He's 18, and candidly, you know what you're missing? Even if every single thing the court said is wrong, you can't do anything about violations from 5-6 years ago to enforce visitations, since contempt revolves around usually enforcement of rights, sometimes monetary sanctions, but enforcement of rights which the court lacks jurisdiction to enforce. The court has no ability to enforce visitations, compensatory visitations. You can't create law, and no matter how many times you file stuff, attack certain judges, you don't change fact patterns and you don't change the law. And you should know that quoting general constitutional access to children cases is nonsensical in a case where the factual underpinnings are that you were placed on supervision 6 years ago and you weren't even willing to show anyone that in the system that, hey, look, have confidence in me. I visited 2 times and it was appropriate. You weren't willing to comply with any order except on one that was totally in your favor and one that you totally insisted on. And that's all there is to it. You won't comply with anything.
Let me ask you one question.
The only thing you're gonna comply with is if there was a ruling that everything these judges did was wrong, they lacked jurisdiction, and that somehow, and that she can be held in contempt repeatedly, and should be, and that even if all that is established, I'm not sure how you enable this court or empower this court to do anything about it now that the boy is 18. I didn't get this case until he was, I think he was already 18 or a couple of months away from it. So that's, so we don't have any jurisdiction anymore. That's it. She's gonna consider or not, and you'll hear from them. Okay, and that's that.
Well, let me say here, on the issue of Donna's house, nobody knows whether it's a private business or a government agency. Perhaps Your Honor could enlighten me,
No,
because I've asked them.
Told you, you know the answer. You know its affiliation and connection because you've researched it extensively. You've even reached conclusions about their complex financial underpinnings, their diabolical motivations. So you know so much about it, obviously, that you don't need me to tell you their connection to the courthouse or their connection to funding. That being said, the important point is I don't see it your way that they keep people on supervised visits for 3 or 4 years to propagate the finances. They have more than a gazillion cases to replace everyone that they close out, and they're eager, as is the court, not just eager but delighted to receive reports that the visitations were conducted appropriately and that I can lift the supervision. And I'm not even much of a believer in supervised visitation. Don't order that nearly to the extent most other judges do, I dare say. And I lift them as soon as practical and appropriate and as soon as I have a reasonably positive report. So you and I have different views as to what Donna's House's function and motivations are, and let's just leave it at that. We have a difference of opinion, that's fine, okay?
They've given me conflicting data about whether they're a private business. They don't say one way or the other. I don't even know who I'm dealing with in there. But the point I keep trying to make...
I don't think it's important. I'm not going to allow myself to get sucked into the vortex of their funding, because I may state something that's wrong, whether it's entirely within the court's budget or whether there's any charitable funding from outside sources. I can't speak to that. You apparently have researched it and you can speak to that a lot more. I don't think that's relevant. I do think what's important is they're there for the purpose of issuing reports, enabling the court, hopefully, in most cases, to lift the supervision. Or in cases where there is a problem, which is the minority of cases, they tell us that as well, and we maintain the visitation until that problem dissipates, which it usually does within a couple of months. Now, if you want to get distracted with their the source of their creation and their funding, and I would imagine Ms. Wilson knows a lot more
funding,
about
are they
it.
public
I
or
would
private?
imagine, since you've done a deep dive on it, I'll concede, you probably know more about their legislative or governmental creation and their funding and budget than the court. I just focus on...
Your Honor, please, either they're public or private. They're either subject to the Constitution or not, and I can't get a straight answer from them whether it's a public or private agency. Okay. That's my problem with them right there.
Okay, they are affiliated with the court. Why don't you speak to... Well, you can speak to this, if Ms. Wilson is a better answer, you speak to someone who knows more about that interplay than the court. I haven't seen a lawsuit or some challenge based on that distinction. The challenge, which I think are all the court is permitted to be concerned about, is the appropriateness of the services they provide and the reports they provide. I think that's what's appropriate. I think it's for other entities than the court, if there is a problem, to do a deep dive on their private status versus governmental entities. As I assume they were part and parcel of the court and the court's budget. They are not one of those outside supervised visitation agencies that some courts refer to. and the modest fee of $20 goes back into the public and court coffers, and they are associated or an outgrowth of the court. That's the extent I understand it. I'm not saying that's right, because I haven't gotten too involved in that, and it's beyond what I'm here for, so. If,
Well, I have
if
investigated,
Ms.
and they
Wilson wants
claim,
to elucidate on that, she can. I'm sure she has a better answer. She may have no interest in placing it on the record, but if she wants to, she can, or you can speak to someone else about it. I think they rightly.
I contacted him directly.
Rightly, when someone comes who they know and researched and who had a case before them, who they don't view you the way you view yourself as a legitimate citizen who has a right to this information, they view it as someone's trying to hang something on us, stir up some trouble, trying to entrap us. So if you go in a confrontational matter, I want a straight answer. I don't think you're going to get it. I think there's, why don't you speak, if it's that important, why don't you speak to the court administrator, why don't you speak to the chief or the presiding judge or someone who, on account of their position, understands these matters a lot better than the court as to the funding source and the private versus public.
I'm not worried about the funding, but Your Honor, I've never.
You can't say you're not worried about funding sources and still say you want a straight answer on whether it's public versus private. That's inherently
Let me explain, let me please.
central to a classification of something as public versus private. Invariably, a financial discussion of funding origin is necessary for that resolution. So, but I can't,
Well,
beyond what I told you, I don't know anything else. If you.
I just wanted to
I
state,
think
Your Honor.
I think you must know the answer after 6 years. I don't know anything more than what I said, which could be erroneous. Okay?
They claim that they are not amenable to public records requests. That's the issue, whether or not they respond to public records requests. They say they don't have to.
My understanding on that is obviously they will not produce anything on someone else's case. I don't even think they're going to produce something on your case unless there's an
They say they're not amenable to
Hold on,
it.
you asked, unless there's an upcoming hearing. If there's an upcoming hearing and one side has a lawyer, they would be entitled to take the copy with them. If one side's unrepresented, they would be entitled to review the interview at that hearing and I believe return it to the court afterwards. But you can't go back to them 6 years later and say, I want to report on this or that. Arguably, they either have no report because you didn't appear, or they have a one-paragraph letter saying you never showed up. And I guess that's all you'd find. But I could be wrong on that. I don't know.
That's, Your Honor, the issue is not whether or not they had disclosable information.
Well,
They
you keep
contend that they're
saying
not
it's
amenable.
Public and private, and when I take the bait and I say, okay, here's what I know about it. Oh, that's not the issue. Okay, if you're concerned about funding, oh, funding's not the issue. It's record disclosure. I have the right to these records. So I take that head on, and then you say, oh, that's not the issue. If you really want to put something important on the record, that's fine. But if you keep wanting to make it clear that you have these concerns which are disingenuous, because I know and it is disingenuous if you state in plain English, this is my concern, and I accept the narrative in that direction. You say, oh, I don't care about public-private, even though that's what you kept saying. And then, okay, what I care about is funding. Then we go down that road. Oh, I don't care about funding, I care about disclosure. I said, okay, here's what I understand about the disclosure records. Oh, I don't care about that. That's not what this is about. If you want to continue this folly, I'm sure, although Ms. Wilson probably doesn't like it because it's wasting time, I don't think she minds you bloodying yourself up on the record, because that's an absurd dialogue to say, but I'm centered on number one, and you state in plain English what number one is. I say, okay, let's discuss it. Oh, I don't care about that. It's number two. Okay, let's discuss it. I don't care about that. It's number three. Okay, let's discuss it. Tell me what number four is so we can discuss it. Then you can tell me you don't care. This is nonsense. The hearing's concluded, and that's that.